The structure of our engagement today is going to be as follows. We will have the panelists just lead us through the conversation on matrimonial property, and thereafter we'll have a Q&A session where we'll have colleagues from the plenary ask questions. Those who are joining us virtually also, please feel free to ask questions via the chat function on Zoom, so you are not left behind. And in the event that there is one or two people who may also wish to just address us and ask a question, you will be given a chance as well to ask a question from your location virtually. We are live at Riara University. Follow us also on our socials at LawAfrica Ltd on Twitter, as well as at Riara University, also on Twitter and on all our other socials. Feel free to join the conversation and engage. I wonder if our honorable judge is available to make just one or two remarks to just say hello to the audience. As we wait for Honorable Justice Musyoka, maybe we can have Leah just say hello to the audience, and then hand it over to Kamencu to say hello to the audience. Then we can proceed. Thank you.
Good afternoon, everyone. Thank you to everyone who's here at the Riara Law School. Riara Law School is hard for me to say. My ancestors keep interfering. So everyone here who's here at Riara Law School, karibuni sana. Everyone who's joining us virtually, you're welcome. Thank you for having us. And I'm here with my associate, Wangui Waihora, who is also a proficient family law practitioner. And we are happy to be here this afternoon. We hope that we'll have an exciting conversation.
Of course, law and who's a colleague, of course, my learned senior, Leah Kiguatha, within the legal profession. Thank you, Leah. I'm here with a colleague, Tracy Mbukwa, who is one of us, and has been out in just ensuring that we deliver on the.
Okay, thank you very much, Kamencu, for that. And let's just get on to today's business then. As you're aware, we are discussing the recent Supreme Court decision on matrimonial property. I think it is the case of Ogentoto versus Ogentoto, and all those questions surrounding the Constitution and the whole notion of division of matrimonial property. So my first engagement would be to ask probably Kimathi to just tell us very briefly, you know, about the concept of matrimonial property. What is the legal definition of matrimonial property, and to whom does this concept of matrimonial property apply?
Very well. Thank you, Daktari, for that question. There are two aspects to that phrase, matrimonial property. There is the property bit, which is understood in different respects in a legal context. You have real estate, which is land and whatever is attached thereof. You have what is called movable property, and you also have a category that is referred to as intangible property. So things like intellectual property, where you're talking about copyright, trademark, and that kind of thing. So that covers what property is. Now, when you qualify with the words matrimonial property, it then carries with it a connotation of marriage. And what the courts have held in terms of defining matrimonial property is property that is acquired in the course of a marriage, acquired before marriage but developed during marriage, and these would constitute matrimonial property. Now, in the Matrimonial Property Act, this actually now finds definition. I believe it should be under Section 7, where these definitions are given, that what is matrimonial property, and even the rules for division of the same.
Thank you very much for that. On to Leah. Let me just continue with that conversation about matrimonial property. We have different formulations of engagement. You know, there are those who got married in church, those who went to the AG, those who gave sheep and goods, you know, then there are those who are cohabiting. So for the benefit of Kenyans and also our students, who is covered by this concept of matrimonial property? If I, for example, am cohabiting with someone for 10 years and we decide to separate, am I covered by that concept of matrimonial property?
I like that question because often it always heads there. We start off with matrimonial property and then we always go to, you know, people who are, I learned a new term for it, Kimathi told me. Until today I was calling it people who are in situationships, but Kimathi will talk a little bit more about that. But mainly it's for people who are in marriage. So you are married under one of the 5 types of marriage. You know the 5 types of marriage are Christian marriages, customary marriages, civil marriages, Hindu marriages, and Islamic marriages. So we have those 5 types of marriages in Kenya. So sometimes people will start to talk about, you know, come we stay, which is quite popular in Kenya. Is it common or popular? It's common. It's common. It's very common. And does that give matrimonial property rights? But I think that's a substantive discussion that we're going to have later. But I think it's safe to say that basically, except in very special circumstances which the courts have discussed, it's matrimonial property. The first basis is that you are married under one of the 5 types of marriages recognized in Kenya.
Good, excellent, excellent. And let me get to Kimathi at this stage. You know, the law on matrimonial property is contained in, among others, the Constitution, as well as legislation and case law. And a number of principles have come out, have been established. So just very briefly, if you could give a run through the main legal principles that underlie the division of matrimonial property, and also when is this property divided, you know.
Thank you for that. And just to echo what my senior has pointed out, is that you have marriages of different kinds, and these are governed by the Marriage Act, which actually defines the kinds of marriage that are recognized under Kenyan law. I guess around division of matrimonial property, I guess the first point would be at the point of entry, primarily because our act recognizes the concept of prenuptial agreements, and prenuptial agreements are basically a pre-agreement on how to settle matrimonial property rights. Will it be that whatever we came in with, we will leave with? Is it that we will say that if something is acquired during marriage and it bears our joint names, it's joint property? If not, then it is our individual property. So one of the things to really bear in mind, and this will become more important as the years go on, is the question of, have the parties attempted to define that by way of a prenuptial agreement? The second level would be where the parties are able to consent. Remember, the whole idea of matrimonial property is that the matters are conclusively determined after the marriage has been dissolved. This is not necessarily the case in other jurisdictions. I know that in some states in the United States, for example, the dissolution of marriage happens side by side with the division of matrimonial property. In Kenya, the dissolution takes place, and then you file a matter in the High Court seeking division of matrimonial property. Now, in the course of that, parties are able to enter into deeds of settlement, where rather than allowing the court to be the one to adjudicate their rights, they can actually say, as we are dissolving our marriage, we are also entering into this agreement around distribution of matrimonial property. Now, these are things that may not find their way into the courts, but they are, as my senior would confirm, and I'm sure that the learned Judge Justice Musyoka would also have interacted with these, that these actually cover a significant portion of potential disputes. So these disputes do not end up being decided in the court. Actually, what happens is that you then register that deed of settlement and say, we have agreed our terms. Now, if it goes to the court, and this is one of the points that we will encounter, especially as my senior talks through the Ogentoto case, the concept of contribution is a very critical aspect of division of matrimonial property. Indeed, in the Ogentoto case, a previous decision by the Court of Appeal, Isharia versus Isharia, I believe I got that pronunciation correct, like Riara. In Isharia versus Isharia, the Supreme Court said that the principles of Isharia versus Isharia, which is contribution, and contribution is both monetary and non-monetary, are good law. Now, this has been advanced into the Matrimonial Property Act, where even non-financial contribution is recognized. The reason it wasn't applied in this recent case is because the case arose before the Matrimonial Property Act came into effect. But where it goes to court, the key question is around contribution. But before that, the court has to exercise its mind to determine, is there a marriage? Once it establishes there is a marriage, then it can go ahead to make a determination on the division of matrimonial property, which is guided, as I have mentioned, by the Matrimonial Property Act and previous law, which gives puts basically a premium on contribution.
Oh, excellent. Do you have anything to add to that conversation? I think there's one or two things that you can also add.
I think just to reiterate what Kimathi has said, that people need to know that you don't have to go to court to sort this issue out. That it is possible for parties to sit down and to enter into a settlement agreement and agree at the point that, and this allows you to do it even, you could do it before you dissolve the marriage and decide how to go forward before you get into the dispute. But if you want the court to do it, you have to dissolve the marriage first, right? So it's important for parties to know that, people to know that you can actually have this settled without having to bring it to a court. It makes for a more dignified process. It makes for less fights, so that you only leave it for the court to decide what it needs to decide, which is the divorce. Number one. The other thing that I wanted to say is that the contribution there are several types of contribution that the court considers. The court will consider direct financial contribution, in that you actually contributed financially to the purchase of a specific property. And then the court will also consider indirect financial contribution, where you were taking care of the other financial issues in the home, therefore leaving some money for capital investments. Maybe the other party's, one party's income is for everyday expenses, and the other party's income now goes into capital expenses. And then the court will also consider non-financial contribution, and that is provided for under the Matrimonial Property Act, and this includes companionship, which is going to be interesting in the future to determine how to quantify that. It also includes childcare. There's a case where the Court of Appeal decides on the basis that there was no child care in determining the shares. So there are very many issues coming up, and then the law is evolving. Because, you know, as Kimathi said, in this case, in the Ogentoto case, the court relies on the case law which was the Sharia case. But that was because that case was filed in 2010, which was before the 2013 Matrimonial Property Act.
Okay, thank you for that. So one is we have a provision for prenuptial agreements in Kenyan law. And the other thing that is coming out strongly is that there is no need to litigate division of matrimonial property, that you can enter into a consent, enter into an agreement, a deed of settlement, so that the courts only come into play when the parties have failed or have not been able to agree on the mode of division of matrimonial property. And of course, it has to be within the context of a marriage that is recognized by Kenyan law. Just out of curiosity, because I know that both of you have practiced family law for quite a while, to what extent are Kenyans engaging in prenuptial agreements? Based on your experience, have people come to you to tell you, I want to get married, I want to do a prenup? Do you have any experience around that?
That is a good question, Dr. Lando. And I mean, you've rightly captured some of the key points that are there. I think the biggest question around are we entering into a prenuptial agreement is usually the first question. Do we have property? That's usually the very first question. Do I have property to talk about as I sign? It's kind of like when you ask Kenyans, have you written a will? And somebody says, what am I willing away? Is it the shoes I wear or my tie? What we have found is, particularly where the age profile of those getting married is a bit higher up on the age pyramid, you will find that those will enter into prenuptial agreements. For those who are coming from jurisdictions, particularly in the Northern Hemisphere, where these have been seen in their environments, they will also be nudged towards that way. Finally, where you have other stakeholders, nowadays there is the concept of blended families, and now people are now saying that, yes, I have my children and all my children are of majority age, and you have your children and all your children are of majority age, and each of them has got a stake on this and the other. You also find a bit more of a push because there's a need to clarify. There's a more intermeshed relationship in terms of each side here. So that has been my experience, but because my senior has been at it longer, perhaps she perhaps would be able to shed more light.
My experience has been similar to yours, Kimathi. The only thing I want to say is that I think in future we are going to go into a lot of people getting into prenups. And I think where we are afraid as Kenyans to get into prenups, it's because we think that we are anticipating a breakup, that you don't want to get into a marriage while you're anticipating a breakup. But considering the cases from the courts, you know, even if you think about Ogentoto, is that eventually when the court decides that that she should have 50% of the, which is what the court decided, that she should have 50%, it was on the basis of documentation. The court says she has shown from her documentation her contribution, because contribution is a big factor. So I think my view is that because it appears from the case law like you must conduct your financial affairs while keeping receipts or keeping the evidence, I think a prenup would prevent you from having to do. You can then relax into the marriage. You can enjoy the marriage. You can give your all in the marriage because you have already ring-fenced in advance. You've already agreed whatever, if this happens, this property is going to be so and so. If this happens, this property is going to be so and so. In fact, I think it will enhance the state of our marriages. I think it will create healthier marriages because everybody can now conduct themselves without fear of what would happen if this thing broke down. Because you've already had a discussion in advance about what will happen if something goes wrong. So you can love without reservations. You can give without reservation because you know it's already decided. I think that considering the decisions that are coming out, because you know, I think there was even a constitutional case where we were trying to push the court to give a clear formula so that the formula comes from court. Give yourself the formula in advance. As you plan your wedding, give yourself the formula in advance, and then it doesn't have to be decided in future. But to be fair, I sort of understand where we are coming from. One, on the issue of we were not planning for a breakup. Two, because our grandparents never broke up. Our grandfathers just brought in a second, third, fourth wife, and our grandmothers stayed. So there were no breakups. So I think we are on the second generation of breakups. So it's new to us as Africans because of the history of polygamy and also the history of individual ownership of property. Because remember that I think titles were not issued before the 1930s. We've had less than 100 years of individual ownership of property. You know, so it was never yours to give. You know, your wife knew what belonged to her. The husband knew. The grandmother, everybody had access. It was shared communally. But now it's been less than 100 years of individual ownership, where now this is mine, it is in my name, and if I am the one to determine what happens to it if X, Y, Z happens. So I can understand why, you know, we're a bit reluctant because we are thinking you don't want to break up, you don't want to think about a breakup in advance because our grandmothers never broke up. You know, they just stayed. And number one, so breakups are sort of, this is maybe first, second generation breakups. And then secondly, maybe third generation ownership of individual ownership of property. My grandfather had titles. I can assure you that my great-grandfather, I can say without doubt of contradiction that my great-grandfather had no title because titles started to be issued in the 1930s and maybe even for Africans, I would say, dare say the 1950s after the Swinnerton Plan.
Okay, thank you so much for that. And just before we get into the Ogentoto case, for those who are joining us virtually, please remember to send your questions via the chat function. We will be getting there shortly. To Kimathi, just one small thing, you know, about matrimonial property again. So if two people are in a marriage relationship, are we supposed to be keeping receipts and evidence that nimenunua gari, I have bought the cooker, I've bought the chicken? You know, how do we help Kenyans navigate that without making it very awkward in a marriage relationship?
Marriages are, you know, we talk about till death do us part, but I think increasingly it is not death, it is till that time when we part. My counsel would be, first of all, that there is need to understand that in the context of marriage, even the courts are hesitant to make marriage about property. In fact, some of the statements in Ogentoto were to the effect that if we are going to say that automatically somebody is entitled to 50%, we are undermining the character of marriage. And there is a public interest consideration there about the health of the nation being very much dependent on the health of the basic family unit. What I would urge around marriages, and I see various communities, whether it is in the context of faith communities or even mentorship that people have, I've seen people encourage couples to be transparent about their dealings with assets. What kind of provision do we have as far as this goes? When we are talking about writing our wills, I have had clients where husband and wife have done mirror wills where they have said that my beneficiaries are my children. If I die first, my interest is transferred to my wife to hold for the interest of the children. And the wife says a similar thing, that if I predecease my husband, my interest, there's a life interest that's conferred to my husband, but all the assets actually go to the children. Now that is only possible in a context of transparency. I think if one is really talking about a proper way of dealing with matrimonial property, you must go higher than receipts and just understand the principle that there are other stakeholders. My senior talked about when titles were held. Now, an interesting thing that you'll find in some communities and some contexts, particularly in rural Kenya, those titles were issued to that generation. Owing to our realities, you'll find that those properties have never been distributed. So they still bear the title of your grandfather. And in fact, Honorable Justice Musyoka actually made a decision late last year where the property was in the name of the grandfather. These brothers were trying to exclude their sisters, and the judge was saying that no, Section 39 of the Succession Act does not make any difference between children. So I think the conversation should be at the level of, let's be frank about property, because it is a big deal. Let's not ignore it. Let's continue to talk about it and even define where we don't have agreements. We say this is a disagreement, but this we have an agreement upon.
Great. Now to the main crux of today's conversation, the Ogentoto case. Leah, could you just take us briefly through Ogentoto case, the main issues? I know it's a long case that stretches all the way from I think magistrates court or something. It goes all the way to Supreme Court, you know. But just at the Supreme Court level, what are the main issues for determination? Just take us through it briefly in the context of today's conversation.
All right. I'm a teacher, so allow me to put on my timer because I could go on and on. I might sit back. I could sit back and, you know, wax lyrical for an hour and a half until people start out. So use my notes so that I don't keep you guys here until midnight. And let me put on, I need to yes. It's for me, really. Oh, you'll prompt me. Thank you. All right, so Ogentoto. So this is a case about a couple. They were married for 18 years. They were both in employment. So the wife was employed for the 15 years out of the 18 years that they were married. Now, they acquired property, including a home in Tasia, which became the main bone of contention. But the husband also acquired other properties. The home in Tasia was registered in the husband's name, all right? So they got divorced, and as we said earlier, you get divorced first, and then you file a case for determination of the division of the matrimonial property. So in the initial court case at the High Court, the judge, the lady was claiming a share, 50% share of the Tasia home, as well as the other properties. Now, what I find interesting is that later on, it seems like all the other properties fall out of the way, but that is consistent with the fact that even if you have acquired property within marriage, not all property acquired within marriage becomes matrimonial property. So that it is consistent with the law for some property to remain as separate property that does not become matrimonial property. So at the beginning in the High Court case, she is asking for a share of all the properties. I don't know how come along the way either she abandons that claim or she doesn't. But what the High Court does is that the High Court says that since this case was filed in 2010 and the Matrimonial Property Act only came into force in 2013, we will rely on the Married Women's Property Act of 1882, which was what the law before the Matrimonial Property Act came into force. And the case that had expounded a lot on the 1882 Married Women's Property Act was the Court of Appeal decision in Sharia versus Sharia. And so on that basis, the court decides that the High Court decided she's entitled to 30% of the matrimonial home and 20% of the rental houses that had been built on the same title, okay? So she gets 30% of the share. She's entitled to 30% share of the matrimonial home and 20% of the matrimonial of the rental houses that they had built on the same title. So that's what happened. And then the parties, as you have said, it's a long case. So it's started at the High Court, because we file matrimonial property cases at the High Court, although now you can file at the Magistrates Court under the rules, depending on the pecuniary jurisdiction of the magistrate. So it went to the Court of Appeal. So she appealed, and she said, 30% is too little, and you did not recognize that I had put in a financial contribution. And the one big financial contribution that she was talking about was some money that she had borrowed and given her husband towards the construction of the rentals, and he denied that he got that money. But she also said that she had shown that she had taken loans to pay for school fees for the children and to build. I mean, she had contributed financially because she had a job, and her husband. So she appealed and said 30% was too little, and 20% of the rentals, that was too little, and she said that the judge should have taken into account the Matrimonial Property Act, okay, which had come in the course of the case, and that the court should have considered just not financial but also non-financial contribution under the Matrimonial Property Act. And then she also said, I think that was the basics of her appeal, but he cross-appealed. Okay, he cross-appealed and said 30% is too much. 30% and 20% is too much, especially because the court relied on a Sharia, and the Sharia had said only financial contribution counts. Okay, direct financial contribution. You must have taken money out of your pocket and put it towards the purchase of this property. That's what the Sharia had said. So he was saying, how can you rely on a Sharia and then go on to give her 30%? In any event, 30% is too much. So he also cross-appealed, and then of course he cross-appealed on the issue of reliance. Said, the court relied on the Matrimonial Property Act, so there was a cross-appeal as well. But the Court of Appeal now listens to the case and actually faults the court for failing to take into account her financial contribution. Because what the High Court had said is that she may not have contributed financially, but she contributed to the welfare of the family. All right? So the High Court had said she contributed to the welfare of the family, and on the basis of this contribution to the welfare of the family, I'll give her 30%. And then, so the Court of Appeal said, no, we have all these loans. She shows that she has taken loans to pay school fees, she has taken loans to build, she has taken loans. And so she has contributed to the property. And the court therefore the Court of Appeal decided that she was entitled to 50%. All right? And so then it goes to the Supreme Court. And the Supreme Court, the main issue at the Supreme Court is when the Court of Appeal certifies the case as a case that should go to the Supreme Court, is because it's an issue of public importance. The decision needs to be made. It's not, in fact, the Court of Appeal says it goes beyond the conflict between the parties. Let's go ahead and decide and make a decision and resolve other disputes as we go along. So the main issue was at the Supreme Court was, does Article 45(3) of the Constitution, remember this case was filed just before the Constitution comes into force in 2010. All right? So does Article 45 mean, because Article 45(3) says equality of the parties at the celebration of the marriage, during the marriage, and at the dissolution of the marriage. So the main issue is, does equality of the spouses under Article 45(3) mean 50-50 sharing of property? Then there was also a side issue, which I'll start with, which was the law to be applied. Was it the Married Women's Property Act of 1882 and a Sharia, or was it the new constitution which came into force after the dispute had already been filed, and the Matrimonial Property Act that had come into force in 2013, which was the law that was to be applied. So that was a side issue. Now, I'll tell you what the court decides about this side issue. About this side issue, the court decides that the Matrimonial Property Act cannot apply because it was not retrospective in nature. So the parties needed, at the point that they filed, the Matrimonial Property Act had not come into force. And so the Matrimonial Property Act takes into account non-financial contribution and lists it very, very well. Says a contribution includes companionship, raising children, running the family business, taking care of the home. All those things are in the Matrimonial Property Act. And the court is saying the Matrimonial Property Act is not of retrospective nature. So we fall back on the Married Women's Property Act and the decision in Sharia, which the decision in Sharia was you had to show financial contribution. And then, so anyway, on the main issue, then the Constitution, there's also the issue of the Constitution. Does the Constitution apply? Can you say the Constitution does not apply because it's not retrospective? You cannot apply it retrospectively. But they say, though with the Constitution, it should be retrospective unless the specific provision of the Constitution says that it should not be retrospective. So because of the breadth and the depth and the fact that it was talking about equality, which is a basic fundamental right, then it is important that you apply the Constitution to this issue. So Article 45 applies, but the Matrimonial Property Act does not apply. And so what do they say about the question, which is, does equality in marriage mean that you must divide everythh equally? So the court talks a lot about this, and this is the depth of the case. How much longer do I have? Anyway, so the case, I always have to catch myself. So the court says that Article 45 does not entitle the court to vary existing proprietary rights of parties. That even with, that's my time, but I'll finish. That even with, even if you say equality in marriage, that equality also entitles you as a party in a marriage to have your own property and for that property not to be taken away. All right, so that's what the court says. And then the court says that it means each party is entitled to a fair share of matrimonial property and no more based on what they contributed. Because the big question has been, is contribution, does contribution, when you say contribution, are you taking away from the equality? When you say it shall be based, which is what the Matrimonial Property Act says, that it shall be divided according to contribution. Should it be divided according to contribution, or does Article 45 mean that you have to divide it equally? So, the court says that it doesn't, Article 45 does not give the court powers to give people property only on the basis of marriage, and that equality of spouses does not mean you redistribute the property. And then the court says that she did prove her financial contribution. So the court agrees, the Supreme Court agrees with the Court of Appeal in that she did prove her financial contribution. She had produced dozens of, no less, in fact, the Court of Appeal had said no less than a dozen loan applications showing all the loans she had taken to pay school fees. She had given cash. There is even one big loan which she had shown was to build a house. So the court says the test to be applied is on a case-to-case basis. So I think what people were looking for was a clear formula from the court. The court says, no, we have to, the fair thing, the equal thing to do is first to do it on a case-to-case basis. Consider that consider equality, equity, and that every party obtains the equivalent of what they contributed, monetarily or otherwise. So you see the court also recognizing non-financial contribution. And finally, the court says distribution should be done not on a specific formula, but on the basis of fairness
on the basis of conscience, and it should not be divided in a way that is unconscionable. So you see a lot of values in terms of what the court, the mindset that the court wants courts to adopt when they are dividing matrimonial property. But the bottom line is that she still gets 50%. I don't know if that's interestingly, the court says it doesn't have to be 50%, but still gives her 50%.
Kimathi, I don't know if you have any additional remarks before we get into the questions from the audience. And I'm seeing also quite a number of questions from our online audience as well. Yes. We will get into those shortly. So just maybe one or two brief comments.
Yes, I do have just 2 or 3 additional comments. Very interestingly, in the analysis, the court, the Supreme Court, that is, had a fairly good opportunity to discuss other cases even beyond Kenya. They discussed a case from the Supreme Court of Uganda, for example. The case, allow me to bring out my inner Ugandan, Rwabinumi versus Bahimbi Somwe, or something like that. And this, they were quoting that case to recognize what my senior pointed out, that marriage does not take away one's right to own property. But more interestingly, they actually quoted a case that arose from the context of the Kadhi courts within Kenya. And there's some very interesting wording that the court quoted with approval from that case. The case in the Kadhi courts is initial UMM versus IMM. And the court says, at the dissolution of marriage, each partner should walk away with what he or she deserves. What one deserves must be arrived at by considering his or her respective contribution, whether monetary or non-monetary. The bigger the contribution, the bigger the share. Where there is evidence that non-monetary contribution entitles one to have the marital property, then the courts should give effect. However, holding that Article 45.3 decrees automatic 50-50 sharing could imperil the marriage institution, and I referred to this earlier. It would give opportunity to a fortune seeker to contract a marriage, sit back without making any monetary or non-monetary contribution, distress the union, and wait to reap half the marital property. That would be oppressive to the spouse who makes the bigger contribution and cannot be the sense of equality contemplated under 45.3. And just Article 45.3. And just to emphasize what my senior has stated, what the court says is that the word equality used in Article 45 is in the context of sharing matrimonial property, translated to fair division, not equal division, fair division. Those were my only additional comments.
Technological challenges happen. As our eminent panel has said, equal rights under Article 45 does not mean you cut the baby into two. It talks about fairness, those principles and their values. So it doesn't mean that a gold digger will come and get married and then sit, distress, and live with half of someone's property, be it a gold digging male or female, whichever. Thank you so much for that. We are joined by Honorable Justice Musyoka virtually. And at this juncture, I just wish to invite him to just say hello to the audience, and then we will probably be taking questions after this. So once we just hear your voice, Judge, and then we will invite you to answer 1 or 2 questions. Okay. Proceed, Judge. If you are able to get us, please proceed by just saying hello to the audience. I think we're still having technological challenges, but I'm sure the Honorable Judge is very much with us and has continued to join this session. Now, we'll take one or two questions from the audience at Riara University, and then we will switch to the virtual audience. I can see we have about 15 questions, but we'll probably take a couple of them, not all of them, because of time. So for now, we can take one question from the Riara audience. Any other persons who may wish to ask a question, please just raise your hand. We will get the microphone to you.
Yes, my name is Kiguatha. Thank you, panelists. Thank you, moderator. This has been extremely intriguing and informative. I was a bit confused, however. If I heard you correctly, the Supreme Court on the one hand says that Article 45(3) does not give a power to allocate proprietary rights. On the other hand, it then says that, it seems to me, that proprietary rights can be allocated on the basis of fairness, the same court. So this seems to be a bit contradictory, and I wonder how that might be resolved. Thank you.
Okay.
What the court is saying is that Article 45 does not mean that you take one person's property and give it to the other person, so that you establish equality. What Article 45 allows the court to do is to ask itself, and I think the court is citing a case, an English case, where what the court is supposed to do is to determine whose is this, whose property is this. So if it was purchased within a marriage, it may be in one person's name, but whose really is it? So the court is not intending to take one person's property and give it to the other person. It's saying this property may be registered in so-and-so's name, but whose really is it? And on the basis of fairness, and on the basis of contribution, on the basis of equity, then make a decision on whose property it really is.
Annette?
Thank you. That was very informative. Thank you so much. Allow me ask a question regarding polygamous marriages. I didn't hear any discussion regarding that. I would want to share a few facts. I'm also a lawyer by profession. What happens, the division of matrimonial properties vis-a-vis polygamous marriages, where you get to a point where the couple has to share the property. So the man is able to, one of the wives is the one divorcing. The man is able to prove his contribution on the side of the woman who is divorcing. But when it comes to the man says, we can't share this property because I have another wife. You are literally taking away our property. I hope I'm clear. So there's a very big issue regarding that. Then number two, does a prenup have to be registered for it to be enforceable? And if so, where? And at what point should it be registered? Thank you.
Thank you, Counsel, for those two questions. My senior has asked that I respond to them. Number one, on polygamous marriages, as my senior pointed out, the Marriage Act recognizes various marriages. Now, under what one would call our typology for marriages, you have those that are monogamous and those that are potentially or actually polygamous. The marriages that are actually or potentially polygamous would broadly be in the case of marriages that are settled under Islamic law or customary marriages. Now, the Matrimonial Property Act takes all these marriages and prescribes basically guidelines upon which distribution, where there is dissolution of a marriage, guidelines that will be used in determining what is the fair share of each individual. Obviously, when one is talking about dissolution of a marriage, it's typically a relationship between two parties. There may be other parties with whom there are marriage relationships, but as you rightly put it, in a polygamous marriage, the question then becomes, how are the rights of each of these captured? The Matrimonial Property Act does make an attempt, and you'll find in those contexts, either the spouse who got married earliest in time might have the edge, if one were to call it that, given the length of time to make contribution, or the spouse who is resident with the person at that particular time might also have an edge. But the Matrimonial Property Act recognizes that even in polygamous marriages, it is possible to distribute properties. And the advantage of this kind of distribution is that it is not without precedent, because if you go into the Law of Succession Act, the Law of Succession Act, I think should be between section 35 and 39, gives the way that distribution is to happen in a polygamous home. It may not be the same in a matrimonial property context, but the point to make is that our courts have had opportunity to interact with the polygamous setup. Obviously, it will be interesting to see the litigation that arises from it, but without a shadow of a doubt, the Matrimonial Property Act would still come into play where there is a polygamous marriage. Does a prenuptial agreement have to be registered? The answer to that is no. There is no requirement under the Matrimonial Property Act for it to be registered. However, it is advisable for that document to be first witnessed. We all, let me not say we all, but the law is that an agreement that relates to property, particularly real property, ought to be witnessed by an advocate. So it is ideal that that agreement be witnessed by an independent advocate, preferably two advocates, one for one party, the other for the other party. An interesting question would be, how would you do a prenuptial agreement in a polygamous marriage? That is an interesting question, but it ought to be witnessed. Secondly, as a matter of procedure, we also advise that those agreements should be stamped, because they attract, under the Stamp Duty Act, ad valorem stamp duty. Now, registration, just because of confidentiality, you might find that people are not very comfortable, but with an agreement that is witnessed, preferably by two separate lawyers independently witnessing the parties' signatures, and a document that is stamped, you have a document that can be produced in a court of law in the event of there being a dispute.
Let me actually read what the Matrimonial Property Act says in section 9, section 8. It says, if the parties in a polygamous marriage divorce or a polygamous marriage is otherwise dissolved, the matrimonial property acquired by the man and the first wife shall be retained equally by the man and the first wife only, if the property was acquired before the man married another wife. And matrimonial property acquired by the man after the man marries another wife shall be regarded as owned by the man and the wives, taking into account any contributions made by the man and each of the wives. And so the question is, how about the women's property? Are women acquiring property in this context? And as Kimathi says, actually the Act does it does foresee a prenup, because it says, despite section 1B, where it is clear by agreement of the parties that a wife shall have her matrimonial property with the husband separate from that of the other wives, then any such wife shall own that matrimonial property equally with the husband without the participation of other wife or wives. And an interesting thing that has come out of from the courts as far as polygamy is concerned is relates to what Kimathi has said about the Law of Succession Act and the division of the houses. And so the wives are considered and the children are considered as units under the Law of Succession Act. And this has created problems for if you have been married for 40 years and then a new wife comes in 5 years and the person passes, should you have the same share? Should you be considered as a unit the same with her? And you see some case law where the court is really agonizing and saying this should not be the case. You can't consider the person who contributed for 40 years the same as the person who came 5 years ago, and even the same as the children who did not contribute. So there are two High Court decisions, one by Justice Kemondo and one by Justice Mumbe Goge, which say no, we are going to consider the patrimonial property of the first wife before who was there for 40 years, put it aside, give her her share, and then distribute to everybody else, including her. So I think it's even just more complex and more compounded in the polygamous setup.
Okay, interesting. Thank you very much, panelists, for that, and thank you so much, our audience, for the questions. Before we get to, let's take one question from our virtual audience, and then we'll get back to the audience at Riara University. There's a question that says, that goes, do courts factor in emotional distress when splitting property, especially when it comes to unfaithfulness in the course of marriage? So, do courts factor in emotional distress when dividing matrimonial property? I will ask Kamencu to think about that. And then for Leah, it's for prenups. When couples decide who takes which property, what if the wife comes in with nothing? Do husbands usually agree to share their properties? I think this participant is just asking about prenups, when one party does not have any property before the marriage has commenced. So let's start with you, Kimathi.
Very well. This is an interesting question. I just wanted to refer to the Matrimonial Property Act, just to list the considerations that come into play when determining matrimonial property, because the question that I hear being asked is, matters such as emotional distress are those items that are considered as far as it goes. Now, the definitions section here because we talked about contribution, and the definition section of the Act speaks of contribution. Now, remember here the context in which it is used is non-monetary contribution. I believe my senior talked about something other than direct financial contribution. So this is what the Act defines as contribution. A, domestic work and management of the matrimonial home. B, childcare. C, companionship. D, management of family business or property. And E, farm work. These are the non-financial contributions that are regarded by the Act. Now, I don't know whether one can quantify emotional distress as one of these items. I mean, certainly companionship, one of the costs of companionship is emotional distress. But if the person is asking whether matters such as cruelty, adultery, the grounds that are used to found divorce, because there are the classical grounds for divorce under common law, which were desertion, cruelty, adultery. If these constitute considerations for division of matrimonial property, they don't apply in the same way. In matrimonial property, one is looking at contribution. But obviously, as my senior has pointed out, the courts look at circumstances, because one of the things about family law is it is very difficult to be very confident going to court with a precedent, because the court may take a different view as far as the matter goes and say that this I can distinguish it from this other matter in determining this particular issue. So in response to that, that is what I would state. Yeah.
And as Leah, you prepared, someone is also asking, I think it's related. So do prenups get updated while in the marriage? Or do you do a prenup and then that is it?
Let me start first by commenting about the issue of emotional distress. There is a dissent by Justice Kiage in a Court of Appeal case where, and it's a dissent, so I have to put it out there that it's a dissent, but where he suggests that there is such a thing as negative contribution, where you put the other party under such distress that it is surprising they acquired what they acquired, that it is surprising that the marriage accumulated what it accumulated. And so maybe because of their behavior and their conduct, courts should consider deducting based on their negative contribution. Now, it's a dissent. But I like, as you know, as Kimathi said, you go with a precedent and the court is minded otherwise. So I like to, when I'm advising the client, to just point out, because sometimes dissents become mainstream, the mainstream thinking of the court, so of the courts. So who knows what's going to happen in future? You know, don't distress your spouse is the I think it's the point. Currently, it doesn't mainstream. It doesn't come into consideration. But with that dissent hanging over our heads, like the sword of Damocles, you never know how it could go because it's a dissent from the Court of Appeal. But let me answer the question on prenups. I think the first question, does the wife, if the wife has nothing. Now, let me say what you're doing with a prenup. So, first and foremost, we marry under separation of property, which means even under the Matrimonial Property Act, property that is acquired before the marriage or that is inherited does not become matrimonial property, okay? But it can become matrimonial property if the other person helps you improve on it. You bought a plot, she has helped you build a house. Or you bought a plot, he has helped you build a house. So that then becomes, based on their contribution, they are entitled to a share of that matrimonial property. So because we marry in separation of property, and by marrying in separation of property, what I mean is what was acquired before does not become matrimonial property, except if the other person improves it, contributes to its improvement. Because of that, you may be making a prenup not based on what you already own. And plus, it's not always just the man who owns and the woman doesn't. I know we are evolving in terms of how we own property and we believe property belongs to men. Or we believed, I think in the 50s, the first titles were all issued to men. But I think it's a long time away from there. And women who own property for themselves. And so when you're making the decision, when you're doing the prenup, you're not really talking about the property you already own. Of course, you're at liberty to mention it and say what I own or what you own remains yours. Or what I own remains mine, but if you improve it, you will have a share. Or if you improve it, it's a gift to me. Because also the law says if it's a gift to the other party, which is shown that you are giving the other person a gift. So when you're doing a prenup, you're thinking about future property more than past property. Now, I think we are confused because prenups are in movies. And movies are from places where people marry in community of property, where you bring in, I bring in, and it all becomes matrimonial property. That's not our situation. For us, the basic requirement is that whatever was acquired before the marriage or what is inherited may not become part of matrimonial property. So what you're doing a prenup about, although you're at liberty to mention the old property, you're doing a prenup about future property. This is how we shall acquire property. When I acquire, if you contribute, this is what's going to happen in the property that we acquire in the marriage. So I think the question was, do husbands do what?
Can prenups be updated from time to time?
Oh yes, prenups can be updated from time to time. There is actually a high court case upholding a post-nuptial agreement. And we are going to run with it until the court says that till the Court of Appeal, the Court of Appeal, not naming names, but until the Court of Appeal says that that's not the position, there is a high court case where the court upholds a post-nup. So even today, you can go and tell your spouse, actually, we've been doing things kienyeji, kiholela, please translate into English. There is an English word for that. Now let us from now henceforth sit down and determine how we are going to deal with our future properties. And there is a High Court case where the court has upheld that. So yes, you can update and you can do a post-nuptial agreement. The Matrimonial Property Act says prenuptial, before the marriage, but there's a High Court case where even a post-nuptial agreement is upheld.
Okay. We are running towards the tail end of our engagement today, and because of time, we may not have not be able to answer all the questions that are coming in from our virtual audience. But I'll just take maybe one from our virtual audience and then one from here, and then we just do concluding remarks. So I think the one from our virtual audience is kindly elaborate on all the taxes to the government involved in sharing of property. So if you do a sharing of matrimonial property, is there a tax implication when that happens?
Where property is being transferred, the basic categories of taxes that one is looking at is stamp duty and capital gains. Those are the two principal taxes that one is looking at. Now, my senior Leah did point out that sometimes people will actually have deeds of settlement before dissolution of the marriage. And that actually works to one's favor from a tax perspective, because in the area of stamp duty, a transfer from wife to husband or husband to wife attracts with it a nominal stamp duty of 200 shillings. Now, this can be very stark. Take the example of an apartment worth 10 million shillings that is registered in the wife's name, and it is being transferred after the marriage is dissolved. If that property is in Nairobi, the ad valorem tax rate is 4%, which is about 400,000 shillings, as opposed to the nominal amount of 200 shillings where the transfer happens from wife to husband. So that's one, the stamp duty tax. The second is the capital gains tax. Now, capital gains tax is charged at a rate of 5% on the computed gain. A very simple way of calculating capital gains is that you start with what was the acquisition value of a property. Let's take that apartment that is valued at 10 million shillings today. If it was acquired at 8 million shillings, the gain is 2 million shillings. So you have 5% applied on 2 million, which comes to about, it should be 5% of 2 million should come to about 100,000 shillings. Now, the capital gains tax, which is under the Income Tax Act, the 8th schedule, there is an exemption for transfer pursuant to an arrangement in anticipation or after dissolution of marriage, when that is taking place, there is an exemption from capital gains tax as far as that goes. So those are the two major taxes that you're looking at. Obviously, for people who are carrying out business, now there are the other business taxes that kick in, your VAT and that kind of thing, but primarily, if you're looking at the actual transfer of the underlying assets, those are the two, and those are the relevant provisions of the law and practice that would apply.
Mm-hmm. And we have seen there is a clarification that CGT is now 15%.
Correct. From 1st January 2023, I see my senior from the Mombasa Law School, Commissioner Mercy Deche, is very alert and saying 15% counsel. So as we say as a junior counsel, we stand guided.
Thank you very much also our online audience for the clarification and for the active participation. There was one last question from the audience here. I think it was Christian to ask the last question, and then we'll take a round of concluding remarks. There is a request from our online audience that could the panelists kindly share their preferred contacts? So that will come probably at the end. And then also, just for information for our online audience, that for those who did not manage to join us from the beginning, this session is being recorded. So it will be availed on our social media platforms for both Riara University and for LawAfrica, and for Misimi Law, and also for Leah Kiguatha and Kiguatha and Company Advocates. Yes. So the session will be available for those who have not been able to join us today. So Christian, please ask the last question for today.
Okay, Dr. Lando, kindly forgive me. I'll have to ask 2 questions, just 2. But on the same, I'd like to comment on the High Court ruling that gave the verdict of 30% of the home in Tasia and 20% of the rental homes that were assigned to the lady. So my question is are those percentages reached using the eye test the judge has, or is reached through evidence that is presented before court? And the second question would be, the Court of Appeal did not faulted the High Court for not considering the lady's monetary contribution. So for her to proceed to take the case to the Supreme Court, what was the verdict reached in the Court of Appeal?
I think what your first question, the acoustics of the room are such that I didn't quite hear. But your first question was
on the percentage.
The 30-20%. It's both evidence as well as the court's discretion. So the court listens to the evidence and then exercises its discretion in determining the percentages of the parties. At the appeal, it is the husband who appealed against the 50-50 division of the Court of Appeal. And, he had 9 grounds of appeal, which I think I highlighted a few. And so she was not the appellant at the Court of Appeal. He was the appellant. And in fact, at the Court of Appeal, she was saying, I did make a monetary contribution. She was not asking the court to rely on her non-monetary contribution.
Thank you.
Good. Yes, so as we close today's session, just want to say thank you very much to our online audience. You've been very active and engaging with us. Thank you to our audience at Riara University. I'd wish to invite our panelists to just make concluding remarks along as I answer this last question. So, on the basis of the Supreme Court's decision, how does this then affect relationships moving forward, especially those who are in marriages, those who are contemplating marriages? What will they be looking out for as they try to engage in situationships, relationships, and marriages? So what would be your advice moving forward in view of the Supreme Court decision and our evolving jurisprudence?
Thank you, Dr. Lando, and once again we're grateful for this opportunity by Riara University Law School and LawAfrica. My view, and I believe it's a view shared by my senior, is as espoused in Article 45 of the Constitution, that family is the basic unit of society. The quote I read that the Supreme Court was quoting with approval, I believe it was Justice Kisakie, that the court is looking at the marriage institution as a very special institution. And I think that's the first thing that one should realize, that it is a special institution. Whatever your persuasion, whether religious or not religious, that it must be recognized as such. So that's the first point. I think let's recognize that when we're approaching matters of marriage. But secondly, regarding property, is to say that it is important to be clear and deliberate, both at the point of entering marriage, in the course of marriage, and in the event the marriage is dissolved at that point, that it is important to be clear, not necessarily at the level of receipts. They do come into play, and as my senior pointed out in the Ogentoto case, the wife was actually saying, I made financial contribution, and here is the evidence. And increasingly with technology, receipts are becoming no longer such a big thing. People are able to produce bank transfers, get statements from 20 years back and say, here was my contribution. I think the clarity should be at the level of how do we regard our interests. One of the things that, as far as matrimonial property goes, that has hung over the legal system has been the question of determining matrimonial property rights without dissolving the marriage institution, because it is possible that people would wish to divide property but still stay married, and maybe in the area of law reform that may be something that we want to consider. But then finally, in the event that there is need to make a division, the view from those who practice in the family bar and bench, and my senior actually sits on the bar bench committee, the family division, is that parties should endeavor to get into an arrangement that they are able to negotiate. And the word that the Supreme Court gives us is fair, fair, fair. I think it is extremely important to capture that point. Obviously, at a future date, we'll be able to discuss other contexts, because a few weeks before the Ogentoto decision, the Supreme Court had also pronounced itself on a unique kind of relationship, which they are calling adult interdependent relationships. My colleague Tracy pulled that out from the decision. That it is possible, what Leah was talking about, situationships, that people are not married and the courts are called upon to determine rights. And the Supreme Court in that decision actually determined rights. It said these people who are not married, actually the High Court started from the High Court. The High Court said these people are not married, we can make no declaration on property rights. The Court of Appeal said these people who are married, we are therefore making a declaration on property rights. The Supreme Court said, hang on, these people were not married. However, we can still determine property rights. And there they use the concept of resulting and constructive trust. But that's for another day. But to the point that I say, I think it's important to be clear when entering into, during the course and at the point of dissolution of marriage. It is important to be fair as far as it goes, and try as much as possible to have settlements that do not necessarily require the court to adjudicate. The court can register a consent, but it is always best from the practitioner's perspective for the parties to agree. And then finally, to realize that we are talking about an institution that even constitutionally is elevated as a basic unit of society. And therefore, as we have these deliberations, let us also honor the institution that we are talking about.
Thank you very much.
So in terms of advice, I think the thing to do is for us to have, I think, a national conversation about what we think of marriage, why marriage is important, and why marriage is privileged even under the Constitution, and how we should go about that. Because my view is that the law should, if strong marriages are a priority for society, the law should come in and allow people to have strong marriages. Because when you think about receipts and keeping of every little piece of evidence to show that you contributed, my view is that whatever you do to safeguard yourself in a marriage weakens the marriage. That's my personal view. That whatever you do to safeguard yourself, not to build the marriage, but to safeguard yourself in a marriage, weakens the marriage. So we must think about, as the case law as case law is made, as we do statutes, as we think about policy, I think we need to think like, how do we allow the parties to build strong marriages so that you can give your all in a marriage, and that if things go south, the law will protect you. And I think if you read Ogentoto, you do see the court talking a lot about values, fairness, of equity and justice, and not enriching one person. And as you said, Dr. Lando, gold diggers can be either male or female, because increasingly it is, the shoe is on the other foot. And then the shoe is on the other foot in a very interesting way, because there are men who are claiming matrimonial property, and it should be decided with fairness. But the interesting thing I see is that there's still an aspect of patriarchy where somebody even wants the salary. You know, he's saying the act doesn't say salary, but I want a share of her salary. So very interesting. So the foot is the shoe is going on the other foot, but it's going on the other foot while with still a stronghold in patriarchy. So very interesting decisions coming out, very interesting situations in life. But I think we need to think in terms of a national conversation and say, what is marriage to us? What does it mean? What does it look like? How do we make strong marriages? Because strong marriages, and not necessarily long marriages, but strong marriages are good for society. So for now, I think do your prenups, keep maybe your receipts, or at least have settlements, so that the court, at the very least, let the court enforce. Let it not be for the court to have to determine what your interests are. But finally, I want to say that it will be interesting to see in future, because this Ogentoto case is decided based on the Sharia, so that it is still her direct financial contribution that is taken into account. It's going to be interesting to see in future, when you talk about indirect financial contribution, those receipts that were for school fees, and if she had not actually paid for the building of the rentals and the house, how would the court decide when it is absolute indirect contribution? And what will the court decide when it is non-financial contribution, where there was absolutely no financial contribution? The comfort we have is that the Matrimonial Property Act has non-financial contribution, the catalog that Kimathi read. But also in terms of discouraging so much litigation, I think if you please agree, if you can, please agree. If you don't, you can litigate. But do you know that in the Supreme Court, the appellant was made to pay costs? In family matters, it's very rare that anybody is ordered to pay costs. But I wonder what point the Supreme Court was making by making the appellant pay costs.
Okay, thank you so much, our panelists. We had been asked if you could kindly share your preferred contacts. I don't know if you just want to give us where we can reach you, maybe your email addresses or your websites for your law firm, so that we can reach you, or your phone numbers if you're agreeable to that.
I won't profess to speak for my senior, but I think the LawAfrica, the fact that they have control of the Zoom, they're able to share my email address there, and our website, Musiemi and Company, one can check it out, Musiemi and Company, and it will give our contact details. But email address can be shared on the Zoom, sorry, not the WhatsApp, the Zoom chat that appears up there, and LawAfrica are well able to do that.
So I'll give our website, kiguathalegal.com. We are on Facebook, Kiguatha Legal, and we are on LinkedIn as Kiguatha and Company Advocates. So look us up and let's talk.
Okay, thank you so much, our panelists. Let's give them a hand. And it looks like this will be the first of many engagements with our partners. There is a question that I think we will be discussing it in another forum, maybe later, on the LGBTQ rights decision and what it says in the context of marriage and matrimonial property. But to our participant who asked that question, we may not be able to answer it now because we are short of time, but it is something we'll be able to explore maybe in our next engagement. Also, for the questions that have been asked, I think our team from LawAfrica will take a list of the questions and maybe then request our panelists at their spare time to do maybe very